Welcome to episode 31 on the law rapport. Today I'm going to discuss exceptional circumstances in sentencing in firearm related cases. But before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. I'll be back shortly. Welcome back. When I make mention of sentencing in firearm related offences, I'm specifically referring to firearm related offences in relation to the Firearm Ordinance of the Turks and Caicos Islands. And I am specifically speaking about those sections under the Firearm Ordinance, Section 3, Subsection 1, Section 21, and Section 22, also Section 27. Now, for an offence under Section 3.1 of the Ordinance, the sentence is 7 years mandatory minimum, but not more than 15 years, and an unlimited fine. For an offence under Section 21 of the Ordinance, the sentence is a 10-year mandatory minimum sentence. The maximum is a life imprisonment or fine without limit. For an offence under Section 22 of the Ordinance, the minimum mandatory sentence is 7 years, but not more than 15 years maximum with an unlimited fine. And for an offence under Section 27 of the Ordinance, the sentence is 10 years mandatory minimum with life imprisonment as the maximum and a fine without limit. So, or for an offence under any of these sections, the sentencing judge is bound by law to sentence the offender to a minimum mandatory sentence unless he finds that there are exceptional circumstances to depart from the minimum mandatory sentence. Now, Section 30 of the Ordinance provides that a sentencing judge shall impose a term of imprisonment of at least the required mandatory minimum term unless a person was under the age of 18 years at the time of the commission of the offense, or b, the court is of the opinion that there are exceptional circumstances relating to the offence or the person convicted of the offence which justify it not doing so. The court, in considering the purposes of section 2, whether a sentence of less than the mandatory minimum term is just in all the circumstances, shall have regard in particular to whether the person convicted of the offence has previously been convicted of an offence under the ordinance. 2. Whether the public interest in preventing the unlawful possession or use or manufacture, transfer, sale, acquisition of firearms would be solved by the imposition of a lesser sentence. Section 4 goes on to state, the following shall not constitute exceptional circumstances for the purposes of subsection 2, justifying the imposition of a lesser sentence. And it says, A, whether the person pleaded guilty to the offence, or B, whether the person materially assisted in the investigation of the offence. So it is clear that the ordinance forbids a guilty plea to be considered as exceptional circumstances. And B, a person who materially assists the police in the investigation by cooperating with the investigation may even lead the police to recover other firearms, to take other firearms out of circulation. That would not be construed under the ordinance as exceptional circumstance. So what is exceptional circumstance? That is the journey that we are going to embark on today. Exceptional circumstances is an unusual situation which is not ordinary for a particular place, time, or situation. And so, a defendant or a person convicted or charged of a firearm-related offense and who seeks to rely on exceptional circumstances must demonstrate to the court that the circumstances, whether his personal circumstances or the circumstances of the offense, is truly exceptional. Now, it is difficult to say that A or B situation would amount to an exceptional circumstance. For the trained legal professional, they will recognize an exceptional circumstance when it presents itself. For example, a person found with a wrong of ammunition, one wrong of ammunition, no firearm, no previous conviction, etc. No way of putting that wrong of ammunition into circulation or committing a further offense could be deemed to be an exceptional circumstance. There was a case where an American sailor was shipwrecked in Salt Cay, and he had firearms that were legally acquired in the United States, and he was shipwrecked in the Turks and Caicos jurisdiction in Salt Cay, and he was charged for carrying firearm, and the court held that there, in that circumstance, there was exceptional circumstances. Now, the leading case and exceptional circumstances is the case of the Queen and Remand of 2006, where the Lord Chief Justice provided guidance as to what might amount to exceptional circumstances and guidance as to the Court of Appeal approach and an appeal from an adverse findings. The guidance is now repeated in the guidelines. In considering whether there are exceptional circumstances that would justify not imposing the statutory mandatory sentence, the court must have regard to the particular circumstances of the offense and the particular circumstances of the offender. So there is a two-pronged approach in determining whether or not exceptional circumstances exist. One is to look at the circumstances of the offense, and two is to look at the circumstances of the offender. The principles that was set out in the case is as follows: that circumstances are exceptional if the imposition of the minimum term would result in an arbitrary, disproportionate sentence. The circumstances must truly be exceptional. It is important that courts do not undermine the intention of Parliament and the deterrent purpose of the minimum term by too readily accepting exceptional circumstances. The court should look at all the circumstances of the case taken together. So there must be a holistic approach. A single striking factor may amount to exceptional circumstances, or it may be the collective impact of all the relevant circumstances. The mere presence of one or more of the following should not in itself be regarded as exceptional. I'll be back to continue the discussion. Welcome back. The Court of Appeal, and this is the Court of Appeal of England and Wales, sought to provide some clarity in the case of the Queen against Avis 1998. After emphasizing the seriousness of firearm offences, including those involving imitation firearms, Lord Bingham, Chief Justice at the time, set out 4 questions which it would be appropriate for the sentencing court to ask itself when carrying out the sentencing exercise for firearm offences. Question 1. What sort of weapon is involved? Question 2. What, if any, use has been made of the firearm? 3. With what intention, if any, did the defendant possess or use the firearm? And 4. What is the defendant's record? The Court of Appeal rejected the need to impose a rigid, formalistic approach to levels of sentencing and instead limited themselves to indicating in what circumstances the maximum custodial sentence may be appropriate. The case of Avis has remained the leading authority for sentencing in firearm offences. Subsequent Court of Appeal decisions have sought to build upon its foundation and provide further guidelines and clarification. In the case of the Queen and Sheen, 2011, the Court of Appeal suggested 2 further questions. 1. Where was the firearm? Or where were the firearms, if there were more than one? Were the firearm or firearms discharged? And who and how many were exposed to danger by its use or their use? Question 2. Was any inquiry or damage caused by the discharge of the firearm or firearms? And if so, how serious was it? In the case of Wilkinson, 2009, the Court of Appeal expanded on the guidance in Avis to address the wholesale importation and distribution of firearms, making clear that such offences should attract a lengthy custodial sentence, in some cases an indeterminate sentence. There is a significant body of case law regarding the interpretation of exceptional circumstances and the procedure to be followed when a defendant wishes to raise such an argument. In the case of the Queen and Nancaro, 2019, the Court of Appeal considered a range of authorities regarding the proper interpretation of exceptional circumstances and set out 8 overreaching principles to be considered. Some of these principles simply restated points made in the earlier case of the Queen and Remand, 2005, including the need to adopt a holistic approach and to consider the arbitrary and disproportionate tests. However, the Court of Appeal also held that sentencing court should always have regard, amongst other things, to the 4 questions posed in Avis when considering the issue of exceptional circumstances. The Court of Appeal additionally emphasized the fact-specific nature of the inquiry, making clear that limited assistance is to be gained from referring to previous court decision involving facts that are materially different than the one to be considered by the court. The court will be very slow to interfere with the first instant decision and exceptional circumstances unless the first instance judge was clearly wrong. So, if your sentence, a person sentence, and at the sentencing they argue exceptional circumstances and that is rejected by the sentencing judge, a higher court, a Court of Appeal, will be very slow in interfering with that decision unless they can determine from the facts and the circumstances that the judge, the sentencing judge, was clearly wrong in denying exceptional circumstances. The decision of the sentencing judge would have to be Wednesday unreasonable, totally irrational, that no informed and properly directed trier of facts could have come to the decision that the trial judge, that the sentencing judge came to. Now I would like to briefly discuss a case in the Turks and Caicos, the case of the Queen and Jude Digener. He was sentenced for keeping firearm and ammunition, and Mr. Digener at the sentence raised the issue of exceptional circumstances. There was a hearing where evidence was given by the prosecution witnesses and by Mr. Digener himself. The sentencing judge rejected Mr. Digener's evidence and disbelieved him in regard as how he said he came in possession of the firearm and ammunition in question. And he was sentenced to the minimum mandatory sentence of 7 years in custody. He appealed against this sentence. I'll be back to discuss this case. We continue the discussion. Mr. Dijuna appealed against his sentence of 7 years imprisonment for keeping firearm and ammunition. And reading from the case summary, before I do, let me say that the appeal was heard on the 25th of May 2020. The decision was handed down on the 25th of July 2022. And reading from the head notes, the case summary, the appellant appealed against receiving the mandatory minimum sentence of a term of imprisonment of 7 years after pleading guilty to the offences of keeping a firearm and keeping ammunition contrary to the Firearm Ordinance. The appellant argued that the sentence is manifestly excessive considering the circumstances of this case, and that the sentencing judge was wrong in failing to find exceptional circumstances which would have warranted a sentence less than the mandatory sentence. The appellant alleged the circumstances were exceptional, as among other things, he only had the firearm for a relatively short period of time. He intended to hand the firearm over to the police, but panicked. He had no contact with criminal elements. He never put the firearm into public circulation. He believed that he had a genuine fear for his safety and believed he was protecting himself and his family from imminent danger. The Court of Appeal rejected those arguments and affirmed the sentence, as they found that the sentence of 7 years mandatory and the facts and circumstances of the case was open to the conclusion which the sentencing judge came to. The personal circumstances put forward by the appellant was that he was a person of previous good character. He was at the time 44 years. He was in fear for his life and that of his family. He had been assaulted repeatedly and his property attacked, causing him to relocate from his previous place of residence. The appellant lived in the country for 21 years without running afoul of the law and is gainfully employed. The appellant is the father with sole custody of 2 young children. Their mother is stuck in the Dominican Republic due to issues with a renewed work permit. The Court of Appeal was not moved by those arguments and found that the defendant's circumstances were not exceptional. So what is the lesson here? Even if you are attacked and you're in fear for your life, there is no sympathy from the court if you go out and get a firearm and say, well, I have this firearm to protect myself. Even if your property were attacked, even if you have to relocate from where you are living, if you have a firearm, even for a short period, and you are caught, you do not have an argument that your circumstances are truly exceptional, and neither do you have a defense. So, what should you do in the circumstances, you may ask? My respectful advice is to follow the law. Here is where I will leave it for today. I will see you in another episode.